can see lots of people joining, but shall we begin? Good afternoon and welcome to this, a further Red Lion Chambers webinar to help fill your Wednesday lunchtime. And who knows, if possible, to inform perhaps just a little. I'm not saying that's perhaps the primary aim, but let's see what happens. I'm Collery and I'm joined today by Faye, Rolfe.
Hello and welcome. Over the course of the next 40 minutes or so, we aim to tell you a little about the overseas production orders. Given the time restrictions, there is a limit to the depth into which we can delve, and we won't take oral questions today. But if you have something to ask, please do post in the chat and we'll endeavour to get back to you with an answer at a later point.
Perhaps I could just say a little bit about the overseas production orders, and that they are the new creatures on the block, perhaps intended to make some of the gathering of evidence from overseas for use in criminal investigations easier, and perhaps above all, faster. Those of you who prosecute will know the difficulties there can be in obtaining evidence from overseas. The intention is that the orders be used to facilitate the easier obtaining of evidence from many jurisdictions. Now that's the intention. We'll see whether that in fact happens. This being necessary because it is taking, for example, an average of about 12 months to obtain material from the USA pursuant to a mutual legal assistance request at the moment. Presently, the obtaining of such investigatory materials and the evidence is largely, though not exclusively, dependent on mutual legal assistance between states. Now, this practice developed from a comity-based approach in the use of letters of request to the foreign state. Now, it's usual for the states to make mutual assistance requests directly to the designated central authority within each state. In the UK, for most matters, that is the UK Central Authority at the Home Office. There are other agencies you need to approach if the request is in relation to tax and fiscal and customs matters, or indeed to complex fraud, bribery and corruption. As you may readily imagine, the HMRC and SFO are then the first port of call. In the United States, the central authority is the Department of Justice in Washington. Now, of course, it's not exclusively by means of mutual legal assistance, because of course, in terms of obtaining material as part of an investigation, law enforcement authorities in this country often obtain material on a police cooperation basis. This remains of use for more informal gathering, information gathering, not so much really for the obtaining of evidence. MLAs have the advantage of allowing the foreign state to obtain material using coercive means. A UK officer relying on police cooperation in another state is most unlikely to be able to receive assistance if, for example, what is sought is material from companies that regard themselves as bound by various domestic data protection legislation. Hence the need for mutual legal assistance. The legal basis for a formal letter of request vary depending on the nature of the investigation concerned. We are party to a number of European, EU convention, and in particular a number of UN conventions that require the signatories to assist each other as part of the stated aims of the treaties. There are also various multi or bilateral agreements for mutual legal assistance. Now, I'm not going to list those now. If anybody wants a copy of our speaking notes in relation to this, please just contact us in the chat on this, and we will seek to give you a copy. These will continue to be used, of course, but will be augmented by new provisions connected to this Act. The existing bilateral agreement with the USA dates back originally to 1994. And requests can be made for documents, and the requested party, so that would be the states if it's us asking, would take the steps it deemed necessary to give effect to the request. The courts of the requested party had authority to issue subpoenas, search warrants, or other necessary documents and other necessary orders to execute the request. Now, taken shortly, therein perhaps lies a difficulty. It means putting the UK request before a foreign court. And here, let's just use the example of the US court. And at that point, the incompatibility between the terms of the request and what was required under US law to obtain the necessary order can become problematic. To give us an example, it might be said that the letter of request did not set out sufficient to found an application that requires a demonstration of probable cause, a familiar common US concept, but not one that we're familiar with. In the US, it comes really from their Fourth Amendment to the Constitution. And I suppose you'd define it as information sufficient to warrant a prudent person's belief that the warranted individual had committed a crime, if you're seeking an arrest warrant, or that evidence of a crime or contraband will be found in a search, if you're seeking a search warrant. Now, we have similar concepts, but nothing quite the same. So resolving these mutual incompatibilities can take significant time. And the agreement contained no time limit, the 1994 agreement, for action on the MLA. As may be appreciated, if you have those difficulties between two common law jurisdictions, it can be more complicated still if it's a non-common law jurisdiction, using perhaps Napoleonic law, which of course you still get in the States if you're applying to Louisiana. So one of the purposes of the one new agreement under this act, the US-UK agreement, says that one of the purposes of the agreement is to advance public safety and security and an open internet, good to know, quotes, by resolving conflicts of legal obligations when communications service providers are served with legal process. So that's the intention behind it. The existing agreement also did not specifically address electronic data. Since the 1994 bilateral agreement with the US, there has of course been an exponential increase in the amount of electronic data held. As we all know, electronic data has the potential to be very significant source for both investigation and prosecution purposes, including the need to make CPIA reasonable inquiries as part of complying with disclosure requirements. So this then is the background really, in part, to the new overseas production orders. It does not cover all evidence gathering. As the explanatory note to the Act provides, the Act grants law enforcement agencies and prosecuting authorities the power to apply for and obtain electronic data directly from service providers. So those who create, process, communicate, or store electronic data for the purpose of criminal investigations and prosecutions. Such orders may only be used when permitted under an international cooperation arrangement between the UK and the country where the subject of the order is located. Faye, perhaps you can tell us a little bit about the detail of what we are looking at.
Yes. Now that Shane has given you an overview of the existing framework of legislation, what are the aims of this new Act? We took the key objectives as being increasing the efficiency with which data can be obtained from overseas, and that's achieved in a number of ways. First of all, it empowers domestic courts to compel the production of electronic information directly from a person or a company located overseas. It negates, therefore, in certain circumstances, which we'll come on to, it negates the need to resort to lengthy and cumbersome MLA channels that Shane has just described, which all too often lead to investigations going cold before the information is gathered. It's also effective by way of bypassing scrutiny by judicial authorities in the target jurisdiction, or the receiving state, as it's referred to in the Act, by the order being granted in the requesting state. And lastly, the order is not limited to service within the UK, but has that extra-territorial reach that we lacked in previous legislation. Sorry, I clicked through. So the Act, in essence, gives better serves the times that we're living in. Now, almost everyone uploads some, if not all of their data to a cloud storage platform, whether that's backing up your personal files to Google Drive, or even the Ministry of Defence in the UK has recently contracted Microsoft Azure to store their data online in a bespoke platform. The cloud in question may not be physically located in the same jurisdiction as the data owner, let alone the agency seeking to obtain it. And as always, the way that criminals operate only gets cleverer and faster. So back to Shane to begin to set out how the legislation aims to work in practical terms.
Yes, perhaps we can go to slide 3. So overseas production orders, section 1, the power enacted, Section 1 and Section 6.4 of the Act provide between them, in effect, that a judge may grant to an appropriate officer an overseas production order requiring a person or company based overseas to produce or give access to electronic data regardless of where it is stored. So, the Act simplifies by removing the need for the request to be by the officer to the foreign state via a UK prosecutor and then to the UK Central Authority, thereafter the request going to the Foreign Central Authority, and then whichever foreign law enforcer is then chosen to facilitate the necessary steps to execute the MLA request. It is intended to remove the need to go via the foreign domestic court. Instead, it replaces it with an order granted by a judge in this jurisdiction, or a foreign judge when it's an incoming order, addressed to the person or company holding the data. Now, at first blush, that appears wonderfully simple. The reality may not be quite so simple. At its essence, however, this is the central advantage. A judge in this jurisdiction grants an order setting out what is required.
So, who may apply for one of these orders? The Act lists appropriate officers in Section 2 and names those as being a police constable, HMRC officer, member of the SFO, a financial investigator, counter-terrorism financial investigators, and Financial Conduct Authority or Financial Services and Markets Act investigation appointees. Those individuals, whoever they are, must specify when they make that request what the electronic data is that they seek, and crucially, the relevant international cooperation agreement under which the order is sought. So you'll see that without there being a separate agreement between countries or blocks, the Act itself has no teeth. So where are overseas production orders currently operative? As at October this year, the only such arrangement that has been finalised is between the UK and the US, and that's called the UK-USA Bilateral Data Access Agreement, which was created by the US Clarifying Lawful Overseas Use of Data Act, better known as the Cloud Act. And in terms of what's in the pipeline, I understand that there are formal negotiations underway between both the US and the EU and between the US and Australia, which still seem to be subject to debate before being finalised.
Thank you. There we go. Section 4 of the Act is perhaps at the heart of it. It provides that the order in the United Kingdom, if we're applying for it, is available if firstly, there is an international cooperation arrangement in place between the UK and the country or territory in which the intended recipient of the order operates or is based. Secondly, an indictable offence has been committed and proceedings instituted or an investigation is underway. Further, that's defined within the US-UK bilateral agreement at Article 4(1)(14) as serious crime warranting a maximum term of at least 3 years imprisonment. So as you can see, that removes some regulatory offences from being covered automatically. Thirdly, Section 4 sets out that the recipient has possession or control of all or part of the data. Now, perhaps an important requirement to keep in mind. Fourthly, that all or part of the data is likely to be of substantial value to the proceedings or to the investigation. That fifthly, all or part of the data is likely to be relevant evidence in respect of the offence. And finally, that it is in the public interest for all or part of the data to be produced. Now, there are a number of key concepts there. The necessity that the recipient of the order has possession of control over at least part of the data involved is plainly crucial. With diverse corporate structures, it's not hard to see arguments about who has possession or control of particular data sets arising. Now, for Europeans, most of the data we store with Apple, Google, or Facebook is curiously not stored in the United States. Much of it is stored in Ireland. TikTok, similarly, presently stores their data for European users in the United States, but within the next few years are moving it to Ireland. So the Emerald Isles server hotels perhaps being more profitable and important to their economy than their physical hotels. It should not matter, of course, if the material is in Ireland, if it is in the possession or control of the US entity. But one can see with corporate structures that it is not entirely clear-cut. In addition, if you look at Section 4, you will notice that preceding most of those requirements are the word reasonable grounds. So effectively, it's lifted into this legislation concepts that we are used to from our own domestic applications or legislation for obtaining production orders pursuant to Section 9 and Schedule 1 of PACE. This, of course, is that it is of substantial value to the investigation and that the material is likely to be relevant evidence. Now, in Schedule 1, curiously, of PACE, the latitude expressed that we see in the Act, where we have the latitude expressed in the words all or any part of it, do not appear. So this may suggest that the orders are going to permit applications and orders to be made when only part of the information requested is going to be for evidential purposes. It could, therefore, include perhaps disclosure purposes, that being part then of the material. We turn on to the next slide. We can see in relation to targets. Now, Section 4.2 provides that the judge must be satisfied that there are reasonable grounds for believing that the person against whom the order is sought operates overseas or is based overseas. In both cases, it must be a country where, of course, there's an international cooperation arrangement. So who operates overseas? Now, this is a pretty wide definition. Section 4.8a defines this as a person who within that country or territory creates, processes, communicates, or stores data by electronic means. So very extended definition. So if your PC uploads to a cloud in a state where we have an agreement, then you are effectively storing data there and you are a person who is operating overseas. The other question was, or the person based overseas, now, perhaps slightly more less extended. Section 4.8b defines this as being, firstly, as an individual's habitual place of residence, or it is where a body corporate is incorporated, or it is a person's principal place of business, or their activities are principally conducted there. Now we'll come back to the significance of this in a diagram that we seek to better describe some of the consequences and limitations that apply in the one existing agreement. Covered providers, now a key concept. The US-UK agreement provides that the issuing party, so in this case it would be the United Kingdom if we're talking about an application to states, issue orders directly to a covered provider. Now that's defined in Article 1(7) of the agreement with the states as any private entity to the extent that it, one, provides to the public an ability to communicate or to process or store, communicate and computer data by means of a computer system or a telecommunications system, or to processes or stores covered data on behalf of an entity described in subsection 1. So again, a wide definition of what is covered that appears intended to cover social media platforms and email providers and indeed cloud storage providers. By Section 3.4 of the Act, it specifically does not include a communications operator. The definition of a telecommunications operator is as contained not in this Act, but in Section 261 of the Investigatory Powers Act. Now, it would be very tempting, frankly, to segue into a closer look at that important limitation. But I'm sure you can see perhaps time's not going to permit it. It's worth bearing it in mind that if a planned order is to be against a company providing a telecommunications service, there are restrictions. Similarly, Section 16 of the Act provides reference to the interception of communications under the 2016 Act that could again detain us for the rest of the afternoon if we were to delve into that. Again, you'll perhaps forgive us if we don't go there on a Wednesday for lunch.
So having set out what can be obtained, what categories of data are protected? Now, Section 3 sets out what cannot be compelled. And that's a subcategory called accepted electronic data, which clearly covers material that will be covered by legal professional privilege, but also confidential personal records. Except where it's something to do with a terrorist investigation, then that exception is waived. Also, as Shane alluded to earlier, where the electronic data is in the possession of a telecommunications operator, then it's exempted. Additionally, Section 6(4)(c) of the Act clarifies that an order does not require the recipient to do anything that would result in them breaching their data protection legislation domestically. So don't worry, GDPR is safe. The applications must additionally be made on notice where there are reasonable grounds to believe that the data sought either is or includes within it journalistic data. And that's set out in Section 12(3) of the Act, unless that data is there to serve a criminal purpose. Or you can get away with giving notice if it would prejudice an investigation of an indictable offence or a terrorist investigation, and it's not reasonably practicable to establish the person's identity so as to enable the service to be effected. Timing is another issue that is something that's one of the positives of this new Act, as well as those 7 days within which it has to be served. It has to be served within 3 months or be treated as quashed. And it has to be served by the Secretary of State in this country, or in Scotland, the Lord Advocate. So whilst the Act is intended to streamline production compared to MLA requests, there is still a requirement for the order, once obtained by the appropriate officer that we listed earlier, for it to be provided to the Secretary of State before it can be served onwards. This is likely in the UK to be the UK central authority within the Home Office, and thereby it's presumed purposefully ensuring that the Home Office can scrutinise and ensure that the orders leaving the UK accord with the international cooperation agreement, such as the UK-USA. And that, we suspect, is also going to cause a little bit of delay in the system. The next one to come on to talk about effect and enforcement. So the default period for compliance with an order is 7 days, with judicial discretion to extend under Section 5, subsection 5. So even allowing for the fact that it has to be served via the UK central authority, there are tight timetables for compliance, potentially much more speedier than we have nowadays. And in terms of enforcing that, it can be treated as a contempt of court. And we can envisage a number of problems there in relation to companies that don't actually have a physical UK presence. Now, it's not quite black and white in terms of the timetable, because Section 7 provides for variations of the order by a number of parties, which includes any person affected. So we can foresee that in the early days of the use of these powers, there may well be many applications to vary the orders, if only as to that timetable element. But we'll return to the nature of potential challenges a bit later on in these slides. Furthermore, an order to produce data is an order that it has to be meaningful compliance. So that data produced has to be visible, has to be legible, and capable of being produced in a form that it can be taken away. So that would mean, presumably, that any service provider complying with an order simply can't give you a load of encrypted data and purport to have complied. And then turning again to the issue of contempt of court, of course, there's the issue with some people not being domestically located here, but also it's whether that threat is enough to force someone to comply. Companies that are worried about their reputation, of course, are likely not to want to be in contempt of court in a foreign jurisdiction, but there are others who may well value the keeping of their data more highly than that. And then lastly, once you've been served with an order, you must not conceal, destroy, or dispose of any of that electronic data, or disclose that the application has even been made without leave of the court.
Thank you. We turn to the one existing agreement. This is the UK-USA bilateral data access agreement. Mutual assurances have been set out within the Act. I think this was part of why it took so long to negotiate it. These are detailed within Articles 1 to 17. Firstly, picking, I'm not dealing with every single one, but picking selectively, there is to be non-targeting of the receiving party's own citizens, which you would see under Articles 4.3 and 1.12. Secondly, to ensure compliance with data protection laws when disclosing data. Thirdly, to not transfer the data obtained to a third country or international organization without first obtaining the consent of the receiving party. Perhaps something we've seen similar in many other, certainly bilateral, multilateral agreements. Fourthly, it's not to be used to infringe freedom of speech or to disadvantage persons based on their race, sex, sexual orientation, religion, ethnicity, or political opinions. And fifthly, to use good faith and reasonable efforts to ensure that the targeted account is in fact controlled by the person referred to in the order. Sixthly, to use intercept material only for a fixed limited duration, no longer than it is reasonably necessary to accomplish their approved purpose, and only if the same information could not reasonably be obtained by another less intrusive method. And finally, to obtain permission from the other party prior to its use where essential interests of either state may be implicated. Specifically here for death penalty cases in the United States and cases implicating freedom of speech in the United Kingdom. So I think it was the UK particularly that wanted, viewed as an essential interests, cases where there were death penalty consequences in prosecutions in the States. Now, the Act received royal assent in February 2019. This agreement, the only extant data access agreement, took 4 years to negotiate. It was signed by both states in October 2019, I think the 3rd of October 2019 in Washington. The agreement passed through the necessary parliamentary procedures very quickly. So by January 2020, it had passed through our parliament. It is not yet in force because it has not yet been ratified by the government. Indications were it was hoped to bring it into operation before now. Then that hope went back to in about November 2020. Present indications are from those who might be expected to know that this has gone back again to maybe March of 2021. The reasons for that delay are perhaps at the moment unclear.
So this is a bilateral agreement, but I wanted to look a little at how reciprocal it really is. The agreement between the UK and the US is unusual in that it appears at face value to be of greater value to us than it is to the US, because it enables us to access data stored in the hitherto impenetrable US tech giants, such as Facebook and Microsoft. I in fact struggled to think of any UK-based cloud data platforms when I was researching this. There's just so many based in the States. However, the US has greater access to UK persons than we have to theirs, and that's because of EU law and how it prohibits discrimination between citizens of different member states within the EU. So we couldn't introduce into the agreement a prohibition on targeting UK persons without also prohibiting any targeting of EU persons from other states. And that would have made it a totally pointless treaty for the US, and of course that's therefore not made its way into it. Then another point is about the permission that's required from the receiving state, where essential interests are engaged, as Shane touched upon. Of course, here we're concerned about people being subject to the death penalty by use of the data we share. And it's important to bear in mind that this agreement was finalised prior to the Al Ghazouli and the Secretary of State for the Home Department case that concerned the ISIS Beatles, who are back in the news again. I want to expand a little on that because it's slightly more juicy than some other aspects of this talk. And where those essential interests are affected, the two identified specifically within the agreements, the First Amendment right to freedom of speech in the US, and for us, protecting citizens from the death penalty. Now, our long-standing practice in the UK has been for us to seek a full assurance prior to complying with any request for MLA that the death penalty would not be sought or imposed, or if it is imposed, it wouldn't actually be carried out against anyone found guilty of a criminal offence arising from the investigation or as a result of the UK assistance provided in response to the MLA request, except in very exceptional circumstances. And this is what's termed a full death penalty assurance, and is what in fact was sought by Theresa May when she was the Home Secretary, responding to a request for information concerning the ISIS beetles, El Shafi al-Sheikh and Alexander Cote. The response from the US in response to that, our request for a full assurance, was a rather carefully worded assurance that no evidence obtained in response to the request would be introduced in a proceeding against a person for an offence subject to the death penalty. In other words, unpicking that, it's what is termed a partial assurance, the practical effect of which is that the evidence actually supplied by the UK couldn't be directly used in order to seek the death penalty, but it would allow UK supplied information to be used for the purposes of a further investigation that then produces evidence that itself can be used without being caught by the assurance given to the UK that can then go on and be used to obtain the death penalty. Unfortunately, the version of the assurance that's made its way into the bilateral agreement with the states is that partial assurance rather than the full one. And that's set out in a published understanding between the US Attorney General William Barr and Priti Patel as Home Secretary. And it also makes its way into the agreement itself in Article 8.4 and Section 16 of the Act. The significance of this is that all that has to be done is for that partial assurance to be sought. It doesn't actually have to be obtained. And that was proposed by Lord Pannick when this Act was going through Parliament. He said we should really include the word received as well as sought, but that was voted down. So all we have to do is request that a partial assurance be given before we will comply. Now, looking back at Hansard, you can actually see the UK did seek to include the full assurance, but we were told that this would be a major stumbling block for the US and for the treaty as a whole to be agreed. Academic commentary has queried whether the resulting inclusion of this mere partial assurance would have been deemed sufficient if the agreement had been struck after the case of El Ghazouli and the Secretary of State concerning the ISIS beetles, because in that case, albeit the Supreme Court didn't go so far as to say that it would be unlawful to share data in the absence of a full agreement, they did emphasise the significance of the fact that that's what we've done to date. So it's interesting that the timing has resulted in it being as it is. Now, I want to turn on to a diagram which is not produced by us, but taken from a blog that I've linked to at the bottom of the slide, should you wish to access it again. This very neatly depicts how the agreement operates. And on this slide, it's when the UK is requesting from the US service providers. You'll see on the slide there are a number of superscripts on the text, and that's because there are points that could be made about pretty much every single word in that first sentence on the left-hand side. But since we don't have time, that's why I've included the link to the blog for you. But if you follow through on this chart, you can see that all of the yeses which appear, they are caveated, and that's because they are all subject to those minimisation and targeting provisions that we detailed earlier. So yes, you can have it, but as long as you've made sure that the essential interests are not being engaged without permission, as long as you've targeted the right person. and of course, as long as you're doing it subject to your own domestic laws. And you can see the downward fork on the slide from the first offshoot is that a US person cannot be targeted by a request from the UK to the US. So that's been carved out within the agreement, protection for their own citizens. And if you want data from them, you have to continue to use the MLA procedures. And the down on in the bottom where you're targeting persons in a third country, if that person is not a US citizen, then yes, you may obtain that data, but you have to notify them. Notifying is not the same as having an opportunity to object to it. So that you have to tell someone you're doing it, unless it would amount to tipping off. But it doesn't actually have any practical effect because you don't have the power to object to it. Now the next slide is very similar, but it's the other way round. Can the US request from the UK data in relation to an investigation? And you'll see on this slide, when the person is located in the US, then yes, they can obtain that information. And however, of course, this is all subject to the same targeting and minimization agreements that we covered earlier. Now, a thing to think about in this direction is the fact that the Cloud Act remains fully in force. And it seems that that, in fact, acts as a blocking statute in relation to collecting information from US citizens. And this agreement doesn't modify that law. So there's still going to be debate about how effective this truly is. And again, as with the previous slide, if you are obtaining that information from a person in a third-party country, you still have to notify them.
Thank you.
Richie.
What I wanted to look at, perhaps in trying to wind it up and in conclusion, is to look at potential challenges that can be we can anticipate perhaps in the early days. Now, these would be related to matters like encryption. What we are to receive must be visible and legible. We'll see if that is always what happens. Secondly, time extensions. As I've said, the Act provides for variations of the order, but can this be done in the 7 days contemplated? Particularly if you're applying to this to the States, are you really going to be getting back and listed in order to vary within the 7 days of you receiving the order? Or is that frankly going to be honoured more in its non-observance than its observance? Thirdly, the conflict between the covered provider's view of data protection safeguards related to its client's data, exacerbated perhaps if the data is actually held in a third country with its own data protection rules. So it's carved out protections in relation to that, but one can see that being a complicated area, frankly, in terms of dispute. And fourthly, in terms of legal privilege. Now, it's perhaps not a great issue in relation to social media accounts, but maybe in relation to material held on cloud platforms. How do you determine what is legally privileged if you're a covered provider, when the UK order may also contain a non-disclosure provision pursuant to Section 8 forbidding you from contacting the owner of the material? So who then in those circumstances is going to determine whether material is covered by LPP? Fifthly, one can see a number of cases where there are going to be domestic knockbacks by the UK Central Authority on the grounds that the order is simply not in accord with the terms of the International Cooperation Agreement. So whatever an officer may have represented in front of a judge at a domestic court, let's say Basildon, it doesn't follow necessarily that that will be in compliance with the international agreement. Sixthly, plainly, there may be difficult to make challenges by the targets themselves, particularly if there are non-disclosure requirements attached to what would be in the main ex parte orders. But one can really foresee some later challenges to the admissibility of the data on, for example, LPP basis, when the authorities seek to use the data for prosecution purposes. So we can envisage these and frankly many more objections that we think will be appearing not long post-ratification in courts in this country. And it has to be said, a fairly intricate piece of legislation, the Act itself. We move on. The Act is intended to provide a much quicker and focused way to obtain communications data. It allows the UK Central Authority to obtain material, as I've said, without having to go through the domestic authorities to the recipient country. We retain concerns how that in fact will work, particularly when you are dealing with smaller entities outside the metropolitan centres in the States. Now, undoubtedly, Google's lawyers will be awaiting and preparing for the receipt of their first order. The same appears unlikely to be true for all of the smaller providers with no presence, particularly in the United Kingdom, who may balk at service when they received an order from Wood Green Crown Court through their letterbox. Now, in those circumstances, what is the UK Central Authority going to do? If this is to be served direct on the service provider, and the service provider balks at complying with it, are they then going to have to contact the local sheriff, let's say in Stebbing, Missouri, and supply him with a copy of the order granted by the judge in Wood Green and tell him to get on with it? Or will, in fact, it mean that the UK will, in most, if not all cases, have to go via the United States Central Authority, the Department of Justice? If they do, how then much faster will the orders in fact be? Because you build in, whilst you build in still 7 days for the response from the service provider, you're building in administrative delays at both ends effectively. So it'll be interesting to see how they work that out. Another question is how many agreements will be concluded, allowing use of these overseas production orders. And this is fairly curious perhaps in that it's an unusual agreement that it's been agreed with the United States first, before perhaps an agreement with some of the other common law jurisdictions, such as Australia. Now, that may be because it was so important, because it was seeking to deal with the cover providers and cloud service platforms, and so many of them were in the States, that we really had no choice. But it took 4 years to negotiate this. It suggests strongly it wasn't plain sailing. We've indicated at least one of the difficulties. On the face of it, it appears to favour the UK in its content, as we've said, for the simple reason that most of the social media platforms and cloud platforms are US-based, not based in the United Kingdom. It's curious, having been through Parliament so quickly, that the government has not ratified it so that it can come into operation. Now, whether the hold-ups are here or in the United States, where the agreement also needs to be ratified, is unknown by us. The hold-up simply may not be here. Be interested if you know what the reasons are. Perhaps you could let us know. So look, that's a whistle-stop tour in about 42 minutes through overseas production orders and the one existing agreement. We hope we've told you something that you do not know and have not bored you completely rigid over the past 45 minutes. You've been watching a Red Lion Chambers webinar. Please check the website and our social media for other webinars coming up in the program, and tell your colleagues if they want to pass the time with a sandwich over lunch, or depending on the nature of your relationship, it's difficult to see how many relationships this is the sort of thing you would share with a friend. But if you have a friend that might be interested, by all means share with a friend. Other than that, thank you for watching, and it's goodbye from myself and from Faye. Thank you.